Hi guys, this is session 4 of the Law of Tort. In today's session we're going to focus on these two parts of the mind map here, looking at some relevant case history and applying it to the scenario. So let's get straight into this. Here is the assignment brief again. Worth looking at. Obviously the submission date's changed now, so you've got the rest of the summer to complete this, and there's going to be all materials on Moodle for this. It should be quite straightforward. It's only one task. You can see what the assessment criteria is and also the grade descriptors, which we're going to look at now. As you can see, it reminds you to use the IDEA method that we've discussed previously. So here are the grade descriptors for those, aiming for merits and distinctions. And remember, you can only aim for a merit and distinction if you submit your assignment on time. This is very important. You must submit on time, otherwise you'll be capped at a pass. Simple as that. So yeah, look at what it says here. Understand the subject. If you're working towards a distinction, then your work should demonstrate an excellent grasp of the relevant knowledge base. So that's why it's important to have things like a good opening paragraph that clearly explains what the law of tort is and the tort of negligence and talks about the elements. And then in the second part, GD2, you're able to apply that, using not so many theories, but using the case laws that we've discussed. That's the most important thing, applying those case laws to the scenario. And if you can do that in an excellent way, then you can be hitting a distinction. And then GD7, quality, the student's work or performance taken as a whole demonstrate an excellent response to demands of the assignment. The demands of this assignment is that it's an academic essay, and therefore you must reference your work correctly in the Harvard referencing. This is our second attempt to do this after law of contracts. I'm looking for good in-text referencing or in-text citations, followed by a good reference section or by bibliography section. And that's what I'm looking for a distinction. It's very important that we achieve this now, because when we get back in September, there's only a couple of months left of the course, and then you'll be off to university, and I don't know what kind of support you'll get there in terms of Harvard referencing, but you should really be able to nail this now, especially if you look at video 3 of the law of contracts. It's all there for you. So here's the situation. It's a car accident. Rupert's driving. There's a passenger. They've both been drinking alcohol, so already some issues there. And they hit a girl crossing actual crossing, I think it's referred to as school crossing. Yeah. So that's an even bigger issue, isn't it? Really, someone is using a marked out crossing to cross the road, and they're hit by a couple of drunk drivers. So it's worth, when you look at these legal problems, to extract the key points, because there's a lot of fluff in there. For example, classmates' school trip to the VA museum. I don't expect to see, when you're writing your assignment, that you mention this. There's no need to mention stuff like this. You can say, whilst returning from a class trip, but things like the V&A museum has no relevance and actually just takes up word count. So when you're developing your academic writing skills, it's important to put in stuff that is relevant and focused to the task, and that means leaving out stuff that has no relevancy. It's just there as part of, in this legal problem scenario, it's just there to kind of give some background, but it doesn't have any relevancy. So it's a good example. That's why I'm going on about it. Okay, so what you do is you look to extract the key points. We've talked about the fact that Rupert, and we need to start naming their actual legal what's the word, legal titles, if you like. So Rupert has been accused of this, and so therefore he is the defendant. Just another point to note, that this can also be regarded as a criminal matter, because driving under the influence of alcohol is also a criminal offence in the UK, so you could actually mention that as a little side point in the introduction. And then we talk about those that are looking to make a claim against Rupert. In this case, obviously it's a civil claim, because as well as it being a criminal matter, Primrose here has been physically and emotionally injured, has the right to make a claim through the civil courts, and that's what she's doing here. She's regarded as claimant 1. Then we've got claimant 2 there, Dahlia, who's talking about severe anxiety disorder, or has been suffering from severe anxiety disorder. And George comes up as a claimant as well, because George was a passenger in the seat and he's claiming that he has severe facial injuries. Claimant 4, Jenny. Interesting. Jenny is Primrose's mother, and she, as a result of this accident and witnessing it, is suffering from clinical depression. And then finally 5, Jake, who is Primrose's father, hears about the accident, has a really big panic, and then suffers later on from chronic fatigue syndrome. So you can see what's trying to happen here with the legal scenario itself. Is, you know, there's a straightforward element to this, i.e. claimant 1, and even claimant 2 is reasonably straightforward. But when you start to go into claimant 3, 4, and 5, that's when you can start to demonstrate your knowledge of the tort of negligence, and that's where you're going to be, you know, getting your merits and distinctions. So let's take a look first at claimant 1. So as you can see here, discuss the liability of Rupert to Primrose, and that's what we're essentially doing for this task. On the left, you can see all the key points that we've extracted from the scenario. Let's just focus now on Primrose. So it's worth noting what's a good idea to do here. And this is why you just want to touch on the elements of tort and negligence very briefly in the introduction. But here, this is where you can kind of examine those elements in a bit more detail in an applied way, obviously to the case of Primrose. So you can ask the question, does Rupert owe, you know, a duty of care to other road users? And of course, you know, the answer to that is yes, and we can look then at the 3-stage test. For example, is there proximity between the parties? And of course, you know, if you consider that the road is shared by, you know, motorists and pedestrians, and it's worth noting, of course, that you know, pedestrians have a responsibility for their own safety on the road, and they are advised or seen to be more careful if they're crossing at assigned crossing points, you know, like zebra crossings and traffic light crossings and things like that. And of course, from the scenario, you know that Primrose was actually hit whilst on one of these crossings. But anyway, in terms of the 3-stage test, proximity is definitely there. Was the injury to the claimant foreseeable? Now, obviously, when you get into a car and you go out, for those drivers in the group, you know, you go out and drive, you generally don't think that you're going to be getting into an accident because you pass your test, you know, you're being careful on the road. However, if you start taking alcohol or drugs, you know that there's a higher chance of that happening. So it can be foreseeable that the consumption of alcohol before driving is a known it's a known fact to cause a lot of accidents. So we can certainly mention that. And is it fair, just and reasonable to impose a duty? So, you know, is Rupert aware of these laws about alcohol? You know, it's something, you know, is this being sprung on him? Is he going to be surprised that he could be, you know, held liable? You know, of course, we know that there's lots of advertising about drink driving. You know, it's a big social taboo, really, to be doing stuff like that. And of course, part of the driving test now, I think, you know, you're made aware of, you know, your alcohol limits when driving. So yeah, is it fair, reasonable, and just to impose a duty? You can explore those ideas. And then move on to the second element. Was there an actual breach of duty of care? So in the case of claimant, it's quite straightforward, really, isn't it? You know, there was actual physical contact between the car and this girl, and there's, you know, physical injuries as well as emotional injuries. We can all, you know, you can bring in also here the reasonable man test as well. That's worth noting. You bring that in. And what we mean by the reasonable man test, of course, is that would a you know, an experienced driver be able to handle a situation of a road driving along on a normal day? From what we can see, it was just normal conditions. It wasn't raining or anything like that. I don't mention anything like that. So we can say that, you know, the average person would have behaved appropriately in driving near a school as well. And it can be seen that Rupert doesn't have any other issues, mental health issues or anything. That's not been indicated. So we can say that Rupert is being judged as the average person or the reasonable man's test, and therefore he's breached his duty of care. Causation. This is the element that is really going to be part of the focus for some of the discussions around claimant 4 and 5. But there's clear causation between, Primrose, Rupert and Primrose because of her physical injuries. And obviously, so she's got harm and injuries. But what I mean by causation is that, of course, the car is traveling on the road. Primrose is crossing on a crossing. There is contact, so it's easy to prove that that car caused the injury to Primrose. So it's quite straightforward. Obviously, when we get to things like clinical depression, could that car hitting Primrose cause clinical depression in Jenny? This is something we need to explore later on. But hopefully that's quite straightforward. So it's also important to discuss this isn't so important for the assignment, but if you want to include this, you can talk about other aspects, maybe relating to how Rupert could defend himself. And there are some situations where Rupert would not seem to be liable in certain circumstances. For example, under the idea of inevitable accident, so no liability for loss or injury arising from a pure accident, as D will not have fallen below the required standard of care. So we're talking about a pure accident, and there's plenty of those on the road. Sometimes during icy conditions, as long as someone has reduced their speed and they're seen to be, the reasonable man test once again behaving reasonably, but sometimes black ice can lead the car to go out of control, then this could be seen as an inevitable accident. There's an example here back when this was first brought about in 1891, and this was just someone shooting a gun and it ricocheting off a tree and then hitting the actual beater, who's someone who walks ahead of the hunting party and encourages the grouse to fly up in the air. So this was classed as an inevitable accident. And that's why the law has these things, because there's some things that you cannot be held liable for. The man here who shot his gun in the direction of the grouse, but hit a tree and then it ricocheted off the tree and hit the man. There's no way that could be foreseeable, and therefore we need things like inevitable accidents to protect us in the eyes of the law. Another one is the act of God. So of course, floods, heavy rain, that sort of stuff can lead to things happening and damage being caused, and we can't be held liable for these type of things. An example here, Nicholas First Marsland. The defendant had 3 artificial lakes. An exceptionally heavy rainstorm caused the banks to burst and the floods swept onto the claimant's land, destroying a number of bridges. So this is like a freak of nature, and therefore the defendant cannot be held liable. Finally, which I think is more relevant in today, and this is just why I'm sharing this one, is this idea of self-defense. The defense can only be claimed where reasonable force has been used. And there was an interesting case a few years ago, maybe some of you remember, where a farmer was convicted of murder because he shot a burglar in the back, a young lad running away from the scene, and so it was deemed that the farmer wasn't under any threat, and therefore this wasn't deemed as reasonable force. Another example here is Reville versus Newbury. Very similar. Fed up with trespass on his land, lay in wait and then fired through a hole in the door of trespasser. This was out of the proportion in the circumstances, and the defence failed. So anyway, that's just a little side point that you could work into your paragraph if you wanted to show that there might be some exceptions for Rupert, but you can then say, but obviously there's no evidence to support any of those exceptions in the case of his liability towards Primrose. So now moving on to claimant 2, we need to discuss if there is liability there. The key thing to focus on here is this concept of nervous shock. We need to consider what nervous shock is. So there's as you can see, there's a definition here, term used in English law to denote psychiatric illness or injury inflicted upon a person by intentional or negligent actions or omissions of another. Sometimes it can, if you don't do something, it leads to an accident and creates nervous shock. You can be held liable for that. The possibility of recovering damages for nervous shock, particularly caused by negligence, is strongly limited in English law for secondary victims. Okay, so this is going to prove quite important later on in your assignment. Secondary victims. We are going to soon make a distinction between primary and secondary victims. Obviously, when you think about it, we just spoke about Primrose. Is she a primary or is she a secondary victim? I think it's quite obvious, even before we get into this, that she was a primary victim. So claiming for nervous shock for her is actually a much simpler task in the eyes of English law. But for secondary victims, and we'll explore who they are in a moment, as it says here, can be more difficult. So Lord Lloyd, in 1995, Page versus Smith, he looked to distinguish between primary and secondary victims, as you can see here. In claims by secondary victims, the law insists on certain control measures or mechanisms in order, as a matter of policy, to limit the number of potential claimants. And you'll understand why. There is a scenario here, or a case here, that was heard in the House of Lords as well, that the claimant had suffered from ME over his life, so similar to what Jake's claiming, and he'd recovered pretty much, but he was involved in a minor accident, and this caused a relapse in his ME. It became chronic and permanent, so he was unable to return to his job as a teacher, and he was successful at his trial and awarded £162,000 damages. So this was held, so it's quite an interesting case. So answering this in regards to the other claimants, we need to, obviously, as I said, we need to explain what nervous shock is, and we need to obviously distinguish between primary and secondary victims, and mention really what are the control mechanisms in relation to secondary victims, which we're going to be doing in session 5. So nervous shock, there's a few little quotes here, involves a sudden appreciation by sight or sound of a horrifying event which violently agitates the mind. So, you can break this down as you're applying it. And when you're talking about, for example, when you start talking about claimant 3 or 4, I think it is Jenny, it says involves a sudden appreciation by sight or sound of a horrifying event. So you can certainly say, if you're a mother or a father and you see your child being knocked down, this is probably the most horrifying event that you may ever occur in your life. So it will, of course, agitate your mind. And so it can, if you can then get a doctor to prove that it manifests itself as a recognizable psychiatric or physical illness, then there's a possible claim to be made. Note here it says mere grief or emotional upset is not actionable. So obviously we can, if we see something shocking, we can get initially upset by it, but then it may go away. But what the law is saying here is we can't make a claim for that. So there's just some extra bits here about what a nervous shock is. Psychiatric injury or illness, it's not a medical term, arising from witnessing a horrific event caused by the defendant's negligence. Once again, just to clarify, it's not mere grief, upset or distress. It needs to manifest itself in a psychiatric or physical ailment or illness. So yeah, what's the difference between primary and secondary victims? Here's a good way of looking at this, just to look at this from a scenario point of view. So a drunk driver plows into a queue of people at a bus stop. Many are killed or injured. These people are all primary victims and can claim for death, injury, and if relevant, nervous shock. Okay, so everyone that's at that bus stop that's been physically injured or killed is known as a primary victim. So several people saw the car approaching at great speed and feared for their safety, although not physically hurt. So they were at the bus stop as well, and actually they were able to maneuver, jump out the way if you like, but they feared for their safety. Sorry, once again, drunk driver driving along. So these people are also primary victims, and can claim for nervous shock. They can't claim for physical injury because they wasn't hit by the car, but they were in, danger from being hit by the car, and they was able to move out of the way. So they weren't physically hurt, but they were, if you like, mentally hurt from the nervous shock. So they can claim for nervous shock. And finally, you can see another scenario: several bystanders who were not at risk of injury themselves. So they're observing the event from a distance, maybe. But they can see it and they can hear it, so therefore they could suffer from nervous shock as a result. Naturally, these are known as secondary victims, and therefore under the eyes of the law, the rules are much stricter. Okay, so just to conclude here, we now understand the difference between primary and secondary victims. We have also looked at claimant 1, Primrose, who is of course a primary victim. In session 5, we're going to look at the remaining claimants. We need to decide, obviously, whether they're primary and secondary, and then consider whether they can make a claim for nervous shock. Okay, because obviously Primrose is the only claimant that has physical injury, so the rest have to be regarded under the nervous shock rule. Okay, so yeah, all this will be revealed in session 5. I'll see you then.